Welcome to Mindful Life 90. I am your host, Nathan Springer. Nice to have you here. We're talking about the news and information of the day as we usually do on all the other Mindful Lives, all 89 before this one. And I'm streaming as usual live on TikTok, on Instagram, and on YouTube too. You can feel free to check in anywhere. The live chat is usually most pumping over on TikTok, but Instagram is there also. And YouTube has the benefit of seeing the articles when I'm talking about it. You can actually see what I'm talking about there. And YouTube has the benefit that the videos are here afterwards. So whether you're viewing it on any one of the other streaming services, be sure to head over to YouTube and hit that subscribe button, hit that like button, drop a comment, tell me what you think, share the videos, share the live. Let's get it further out there. So yes, now however, the disadvantage if you're over on the YouTube live stream, as maybe known by now, it's a little delayed, so I read what you say a little more delayed than if you're over on the other live, so there's that benefit. Either way, I'm glad you're here. Mindful Life number 90. So yes, as that might suggest, there were 89 before this. Wow, so YouTube live seems to be, sorry, not YouTube, the Instagram live seems to be giving some trouble there, but normal thing, the show goes on. The topic of tonight that we're getting into has to do with crime and the judicial system and law and justice and courts and judges and how it runs in Trinidad and Tobago. Now, I spoke about some issues that arose in our judicial system, something that our appeal court ruled on recently. Good night, Andy Scipio. We have to talk. Well, my DMs and inbox are usually open. They're open on nearly everything, so feel free to hit me up whenever you feel like it. But yes, the court system. Recently, our appeal court ruled that the bill to stop bail from being accessed from the murder accused, the appeal court ruled that was unconstitutional and it wasn't a good law. They struck that law down. I believe that case is currently in front of the Privy Council because our government wants it to remain as is. They do not want those who are accused of murder to be able to access bail. That's what they have said. It's widely known now. And that was the previous bill. If you are charged with murder, if the police charge you with murder, if they believe that they have enough evidence to charge you with murder, then you were not able to access bail. Good night, J. Chris. Nice to have you here as per usual. But yes, you were not able to access bail. Now, the problem with that was some people were saying it's not this was the two reasons that the appeal court basically used to strike this down was that one, the purview of granting bail or not is in the court. That is not for the parliament to decide. They are not there to go sign some bill, some law into being saying that no, you cannot access bail. No. That's not their purview. That's not their job. That's part of what the appeal court said. Also, what they pointed out was someone is innocent until proven guilty. And as it stands, when someone is able to access bail, that is before they are convicted. That is before they are proven to be guilty. So you cannot treat them as if they are guilty. Therefore, not allowing them to access bail by default is inhumane. And the fact that this is supposed to be in the purview of the court in the first place, what the appeal court pointed out was that the justices in the court are living people they are aware of the laws, they are aware of the context of how dangerous murder is and how potentially dangerous an accused murderer might be, and they're saying that that is the job of the judges, the justices in the court system to decide that. That is their purview, to look at the merits of each case and decide whether bail is warranted. So they struck that down. And there are many murder accused people who have been requesting bail since then, and some have been granted. And I'm going to look at the first one in Tobago that was granted. Yes. A murder accused out of Tobago was granted bail. And let's see the circumstances surrounding this and see if now we could take more to the appeal court's view of this thing, where automatically refusing bail on murder accused is inhumane and cruel. Let's stop that, as the appeal court rightfully said. Or if you take the government side, where this is very dangerous, you're letting murder accused people just out on the streets just so. We do not want this. We do not want people accused of murder, potential murderers out there. Wendy Medium Excel over on TikTok is already voicing her opinion, saying she agrees with the government's perspective. No bail for those accused of heinous crimes. Now, when the Medium Excel, I'll say it one time early up, bear in mind, you used the correct term there, accused. These are people accused of heinous crimes, not yet proven that they have committed them. All right, let's get into the article from the Newsday. Tobagonian on murder charges, island's first successful bail applicant. A High Court judge has granted the first bail application to a Tobagonian charged with murder. On Tuesday, Justice Geoffrey Henderson granted bail to Hubert Guy. Wow, that sounds kind of... I'm sorry if I'm being very stereotypical here, but for some reason, Hubert Guy sounds very much like a Tobagonian name. Blessings, Ria. Welcome. Nice to see you in the live. But yeah, Hubert Guy, it sounds Tobagonian. Like if someone said, I know a guy named Hubert Guy, I'd be like, I feel he from Tobago. Just passing through. Nice to see you nonetheless, Ria. Nice to have you in the live for the little while. All right. Mr. Hubert Guy, 59, of Falcon Drive, Susulands, Tobago, in the sum of $1 million with surety. That was the bail he was granted. $1 million with surety. As part of the conditions for bail, Guy has been ordered not to visit Jiggers Hill Mason Hall, where the alleged murder of his nephew took place, and to have no contact with any of the state's witnesses in the case. Blessings, good night, super hype over on Instagram. Nice to have you in the live as per usual. So he was accused of murder and he was granted bail. This is the very thing that the government has been warning about. The very thing the government has been warning about. These people that have been accused of murder are granted bail. Guy is before the court charged with the murder of his 18-year-old nephew. Far too long has the restriction of bail been used as a bandage for an incompetent police service. Ooh, I like that one. Gamer State, I like that one. He was charged, although having... Hey, you're going ahead of all these cases. But yes, I know about that too. And that's part of the problem, even in this too. All right. This man was charged with murdering his nephew, 18 years old. It is alleged that Sebra was fatally chopped while going to his mother's assistance during an altercation with a relative. The preliminary inquiry into Sebra's murder is yet to start, and Guy's attorney, Azim Walters, made the bail application, which was assigned to Henderson 2 weeks ago after it went before several masters of the High Court's Criminal Division. All right, so he was charged with murder after allegedly his nephew intervened in an altercation, and apparently he killed his nephew. Walters urged that his client had no previous convictions or pending matters, and there was an element of provocation in the prosecution's case against his client. And then is the facts of the matter. You see, when you have a rule as all-encompassing as something like no bail, no one accesses bail once they're accused of this specific crime, then you throw nuance out the window. This guy's lawyer was pointing to the fact that he has no previous convictions, no pending matters, and he's an ageable guy, 59 years old. So that says that at least for some time now, 59 years, he hasn't been in trouble with the law. That should count for something. And then they're highlighting that there's an element of provocation in the prosecution's case against the client. Now, here's the thing. I don't know the facts of the issue. I wasn't there on that fateful night when whatever occurred, or fateful evening when whatever occurred. I don't know the reality of it. But that's the job of a judge. Maybe in this very case, as his lawyer pointed out, there's some element of provocation. There may be some provocation that led towards the physical altercation that ultimately led in the person's death. And although the man may be charged right now with murder, in the progression of the case, as happens sometimes, next thing you find out that the actual charge that should have been laid should have been something like manslaughter or something to a much lesser extent. Or next thing it turns out it was actually self-defense. And this person with no access to bail in a country like ours, where these cases take years, would have been forced to sit in jail while this case went on. Sitting in jail, even if they may not have been as direct of a murderer as they were accused of. So this guy here, this guy named Guy here, do you think the proper thing there should have been to leave him in jail? This 59-year-old man, never before accused, never before convicted of anything, no pending matters. There is allegedly an aspect of provocation inside of the case. Would that have been the better outcome for the country? I don't know that I would automatically say yes there. Maybe not. And I think I would prefer that a judge has the ability to decide this. And I guess that's the whole idea behind it. You want the judicial system where these judicial officers, these judges, are able to have the stop measures in place to protect people out there. Yes, because he chose to use a weapon instead of walking away. Well, when the medium excel, I think you may be assuming a lot on a scenario there, on a given scenario. Are you saying that there's no possible scenario where someone can use a weapon and someone dies, and the person using the weapon was in the right? Don't you see that being very possible? Or don't you see a possibility where someone can use a weapon and the person who resulted, the death resulting from it would not have been on purpose? That wasn't their intention. Once a prima facie case can be made, make jail. I disagree. And here's the thing here, you're quoting legal terms there, but the law disagrees with you also here. Like, that's an opinion you're stating there, because according to the law, that is not what should happen. And personally, I agree with the law of our land in this case. I am glad the law of our land is not in the hands of people who would make these decisions more emotionally, because some of us may end up in the very same situation where a whole scenario plays out and the situation is extremely complex, and it's something that you need to stand in front of a human being and explain. You need to to unravel this scenario, whatever played out. Listen, this happened and then this happened, and you have to understand that this was happening at the same time. And also, Your Honor, this was also happening, and at the same time it was this and that and that and the other thing. And I didn't even have it. This thing fell into my hand, and etc. and etc. and etc. and etc. and etc. and etc. And you explain it to a human being, and that human being says, you know what? As it stands here, although you are accused of this extremely heinous crime, I think until we can make a sure case and prove that you have committed what the state accuses you of, let's relax on that. And here's the scary thing. Richard Glubman, one of my regulars on TikTok, he always insists he's not an officer, but he usually takes the view and the position of the officers. And here's the scary thing: if some of those positions are the ones that are held only. Now, Hunake, I am going to get to that because it's an article I have pulled up. Hopefully I can get to the cruise ship and the jobs, etc. Hopefully we can get to that. But yes, good night, Easy 868. If some people who have the view that whatever you're accused of, once the case is going on as a murder accused person, you should remain in jail, that gets scary. Historic defeat for DPP. Judge rules DPP's office abusing court process. Greetings, sir. What's up, man? For the first time in the Commonwealth, the decision of the Office of the Director of Public Prosecutions to prosecute someone on a charge of murder has been found to be improper and an abuse of the court's process. In a split decision delivered at the appeal court yesterday, two judges, including Chief Justice Ivor Archie, dismissed an appeal brought by the DPP's office. That appeal was against the decision of a High Court judge who had also ruled in 2019 against the prosecutorial process against 3 murder accused. The third member of the appeal court, Justice Nolan Barrow, dissented, disagreeing with the findings of Archie and Justice of Appeal Peter Rajkumar. The reason for the ruling was because prior to the murder trial coming to a start before Justice Devan Ramprasad, the state's main witness confessed to the prosecutors that he had fabricated his statement to police against the accused men and also gave false testimony against them at the magistrate's court during the preliminary inquiry. So the state's main witness admitted to the prosecutors that, y'all, I made it up, I fabricated some of the evidence. He confessed to fabricating some of the evidence. He also vowed to continue telling untruths at the trial to have the men convicted. So he said, listen, I lied before. And then he said, I am giving a vow that I'm going to continue lying to make sure these men are convicted. Richard Glubman says in this case, he boldly says the DPP was wrong in this one. But if his view of the court system is to stand, the DPP was wrong on this one, oh gosh, snap, is what he would type in the chat, while someone who was accused of murder and the DPP was wrong on this one, oh snap, could have spent 5 years in jail waiting to find out the DPP was wrong on this one, oh snap. And that's the attitude that I despise in people inside of our judicial system and people inside of our law enforcement. People look at other human beings' lives so trivially. They are willing to look at someone else and on the possibility of this person being innocent, throw them into jail for 3, 4, 5 years. That is evil. That is evil. And listen, if you believe in sow and reap, if you believe the world is a cycle, and you are engaged in things like that, where you so flippantly cause the loss of years of people's lives, that is coming back at you. That is coming back at you. That is some evil stuff. Downright evil. I can't find an excuse for that on my side for police officers who so flippantly they're talking about years off of youth lives. Off of youth lives. Like an 18-year-old, and you're unsure about this, and you know what, whatever, throw him in the system, let them deal with that. And you know very well this youth thrown in there at 18 might come out of there at 26 being abused, being assaulted in the jails. You know that, and you just do that so flippantly. Like, I no, that's not what the justice system is. As I said in the previous videos I did on this topic, where I agreed with the ruling from our appeal court that it is inhumane to force someone into this process automatically without giving them a hearing to determine whether they're worthy of bail. I think that's inhumane because according to the Blackstone's formulation that our jurisprudence, that our legal system, our innocent until proven guilty legal system is based on, it's better that 100 guilty men go free than one innocent person is punished. And if you cannot understand the morality behind that statement and understand why in a moral sense that's okay, because you're so caught up with the guilty people going to jail, understand that on the side of keeping and maintaining a society that works, if you start locking up and punishing innocent people, the judicial system would not be seen as fair, and it would not work, and your society crumbles into anarchy, because no one can be managed based on laws. We cannot be a society of laws and rules anymore if the laws and rules are seen to be abstract, seen to be vai, not held up with any legitimate standard. So no, we don't want that. But the reason now, this gets in a little more complex here, this specific case, because the reason that the witness chose to lie gets interesting. I'm not sure exactly what you're referring to there, but the reason the witness chose to lie gets very interesting, because the witness said why. The witness said why. And by the way, it should be noted also, he was the sole witness, the only direct evidence linking the three to the crime. Benjamin reportedly claimed, that's the state witness, he was willing to continue to lie at the trial as there was a drop in crime within his community after the men were charged. Now, that adds an interesting angle to the case, because then I could probably understand why from the prosecutor's side, the DPP side, they may see it as we're still trying somehow to get these men convicted. Because although the witness is saying he lied about knowing for sure that their whereabouts for the actual crime, the witness is suggesting that he is knowledgeable that these men are involved in criminality in the area. So there may be some assumption that they may have been involved in this crime that they were accused of, or at least several other crimes. That's the assumption. That may even be the knowledge, but we know, we also know that the legal system, the court system, doesn't work like that. It's not what you know, it's what you can prove. So yes, they may know, some of the police in the case may know, some of the witness may know, some multiple people, informants in and around the community may be saying that, yeah, these men are involved in XYZ and but again, if you cannot prove it, if this witness he figured, he kind of knew, as villagers know. As villagers know, you know, as a villager, you always know who do whatever in your village. Like in a village, I'm whenever I hear stories from my fellow villagers and stuff, I like to ask, you were there? Like, they're there? because villagers could tell you a story like they were there, and they heard it from the third person in the chain of hearsay. That's how village talk goes sometimes. We know this. It's a fact. And it seems like his witnessing of the crime had a bit of the village element in it, where he may not have been certain, but maybe through the accumulated knowledge of the village, the general story is, yeah, these men did it, but no one person saw it, or the one person who saw little bits of it wouldn't come forward to say so. So who knows, whatever was whatever. The fact is, this witness didn't witness it. But he is saying that, hey, since these men out, crime drop in my community. So if I have to perjure myself to keep the crime low in my community, it's a sacrifice that I am willing to bear. He said that to the prosecution. Now, he said that to the prosecution, to the lawyers on the prosecution side. And it seems like that made those lawyers a bit uncomfortable. They weren't very okay with that. However, it seems like the DPP was. While the matter was at the case management stage, court documents stated the prosecutors raised with the trial judge serious concerns they had about the legality, fairness, and lawfulness of the continuation of the trial against the accused persons. Later that day, one of the prosecutors also raised concerns with one of the attorneys on the defense team, and without going into particulars, again expressed his concerns. So the prosecution went to the defense and kind of gave them a little signal, something kind of wrong with this case. They didn't get into the particulars, into the details, but they gave them the signal, something a little wrong. Everything in this case isn't 200. Look into it a little more. Later that day, lied under oath. While the defense had made an application for disclosure, so the prosecution gave them a little wink and a nod of something going in a certain direction. So the defense made an application for disclosure, by the office of the DPP as to exactly what was the cause for concern. The information was not immediately forthcoming. About a week later, though, on the morning of May 23rd, the disclosure was made. It was only then the defense attorneys were made aware that the witness had confessed he lied under oath. So it seems like the DPP was interested in hiding this matter. Isn't it a charge to lie under oath? Yes, it is. It seems like the DPP was interested in hiding this matter because, one, the DPP himself didn't disclose it. One of the lawyers working the case kind of hinted it to the defense, and only after the defense made an application for disclosure. Well, when they made the application, the DPP didn't even respond immediately. It took a week, and only a week after, finally they found out, well, yes, the witness admitted to us that, yeah, he did lie. But instead of discontinuing the matter, the DPP's office took the decision to proceed with the trial and replaced the two previous prosecutors. Like, bro, say what? The DPP decided to still proceed with the matter and replace the two prosecutors who obviously from their actions, those initial prosecutors seem to obviously have a problem with how this thing is going. It doesn't seem to be heading in the direction that they are comfortable with. Something doesn't seem to be above board here, and the prosecutors are trying to highlight that. And the DPP says, okay, we hear you. Go work another case. Here's a new case. You go work that case. All right. They left. Hurry! Yeah, hurry, come. New case for you. And just brought in someone new. The police and prison officers and other law enforcement, free and clear. I do not care if they are free and clear as of this specific case, because the whole system works together. And you're saying that you're promoting the idea that someone who is entangled in this system where they obviously are corruptible members. We've seen numerous times where the police can be corruptible. We've seen now where the DPP, let's not say it's corrupt, but something strange is going on there. And we see this. And you're saying regardless of this, someone who is accused by this system. Now, here's the thing. The balancing of this is a jury of your peers is supposed to convict you. So this system of professional people who went to law school to study whatever, they aren't the ones who are supposed to really determine if you are guilty. A jury of your peers is supposed to determine that. That's how we figure out the justice in our justice system, supposedly. So I don't want these people that I know can be corrupt from the very bottom of this system straight to the very top. I know they can all be corrupt. I don't want them on their say-so to be able to lock me up for a decade. That's what I'm saying. I don't understand how anyone could look at things like this, see how our court system functions, see the corruptible and fallible police service, the corruptible and fallible prosecutorial office, the corruptible and fallible judicial system itself with the judges themselves, and say that, and also the fact that that whole system takes extremely long, and then say that we would want anyone accused of anything by that group to be put in jail without any bail, any, what's the word I'm looking for? Respite. Any way to escape that. I don't think that would be a good thing. That doesn't sound like a good idea to me. All right, but this action from the DPP resulted in the defense filing judicial review, as probably they should have, proceedings against the DPP's decision. Just over a week later, Justice Avison Quinlan Williams ruled in favor of the men. In spite of resistance by the new attorneys of the state, that same day Justice Rampersad quashed the indictments and ordered that they be immediately released. By the way, the following year, one of the accused men, upon his release the following year, died of drowning. That is just some Final Destination sad kind of stuff. But yes, unfortunately, he did die. Now, the reason that the DPP used actually is kind of in line with some of the arguments the Chief Justice himself, Justice Ivor Archie, laid out when he struck down the bail bill. The kids would not have withstood scrutiny, the case, I suppose, on appeal because it would have been fruit of poison, yes. Justice Quinlan was the first instance judge, Rampersad was in the appeal. Thank you. Do you support a three-strike law to prosecute criminals? I don't know that. I guess that question is too much in a vacuum for me to answer that. Three strike as pertaining to which crime? From what age? I don't know. I think there needs to be some more factors put in there for me to answer that really and truly. But yes, the reason that the DPP gave actually was in line with some of the reasoning that the Chief Justice gave when he struck down the bail bill, because what he was saying was, this is the job of the court. That is what the DPP was saying. This is the job of the court. So whether the DPP put it this way. He was unsure whether the witness lied in his original statement or whether he is now lying that he is lying. So he is unsure. So what the DPP is proposing, this is the DPP's logic, his rationale. He is proposing that you carry the case to court, you put the witness on the stand, and then the prosecution can question him, and the jury would make a determination on the veracity of his word, whether he lied or not. And the defense has a chance to question him too and show that he might be an unreliable witness. And the court system would see about this. The jury might still determine that the men were not guilty, and then the court system still works. That's the DPP's logic. And here's the thing. in a sense, that's what Chief Justice Ivor Archie said, part of what he said with the bail bill. He said that bail is in the purview of the courts, and it's not for the parliament to decide automatically that someone doesn't get bail. You bring it before the court, the judge, and the court determines the matter. And that's what the DPP is saying. The court should determine the matter. Now, Justice Ivor Archie didn't deny this. Let me see if I can get his statement here. Let me see if I could get his original statement here. Archie chose to clarify his position, agreeing with Bago that the question of an accused receiving a fair trial was one for the trial court. Now, let me go down to the end there a bit and give you the version, because one of the justices in the appeal court agreed bail and the perverse verdict due to a lying witness are two different things. I am not disagreeing, Mr. Rafa Trini. I am saying the arguments that the DPP proposed and that one of the appeal court justices kinda agreed with. Let's see if we could get Mr. Bago and what he determined this to be. In his dissenting reasons, Bago held Quinlan Williams was plainly wrong, that's the previous judge, in her findings, and the DPP's decision to continue prosecution was consistent with his constitutional duty and discretion under Section 90 of the Constitution. He said there was nothing exceptional in this case that could not be dealt with at trial. The prospect of future witnesses changing their accounts privately to prosecutors after having given sworn evidence in the magistrate's court looms large here. Any witness doing so should be confronted with their inconsistency in open court at the criminal assize and then face the likelihood of a perjury charge in that event. He said, faulting the majority ruling and holding that the trial judge had usurped the DPP's function. Good night, I love boots. That's what the dissenting justice found. He agreed with the DPP that this should have been left in the purview of the trial court, that whether the witness lied or not, when he reached to trial and he reached up on the stand, he could be questioned on that matter, and then if it is proven that he perjured himself, he would face criminal prosecution for that very same thing. That's what the dissenting view was. Now, let's see what the Chief Justice said to clarify his view, because we know previously that the Chief Justice was of the view that the court is to determine what the court is to determine. What is within the court's purview should be left to the court to determine. So let's see how the Chief Justice clarifies his opinion here. Archie chose to clarify his position, agreeing with Bago that the question of an accused receiving a fair trial was one for the trial court. So he agreed on that ground, that where the accused is to receive a fair trial, is who is to determine that is up to the trial court. However, he said, in this case, there was a sole witness who perjured himself. One witness. The case, for the most part, was based on one witness. And the one witness already admitted to perjuring himself. He said that he will continue to do so at the trial. Even if he restricts his admission, there is no he retracts his admission, there's no conceivable direction from a trial judge that can mitigate the risk of an unjust verdict. Because the problem here, good night BJ Pilot, the problem here is that he lied then, or he lied now, and then he promised he would continue lying. So there's no possible way for us to know whether this man is going to tell the truth or not. You don't know where is head or tails in here. You don't know if the original statement would be true. You don't know whether his recanted statement would be true. And that's what Justice Ivor Archie is saying here. Even if he retracts his statement, there's no way you could figure this out. Archie said the difficulty with the DPP's position here was when he acknowledged he could not decide whether the witness had lied at the preliminary inquiry or was lying to him now. In those circumstances, the DPP thought that the matter should be put to the test in court and determined by the finders of fact. That is wholly inappropriate engagement of the court's process, Archie said. We are, and the DPP should be, about protecting the process. The exercise of prosecutorial discretion is a part of the process. We must be able to trust that too. All right, so this was kind of the conclusion for this matter on the DPP's ground. So the DPP's basic argument is that they should have continued along in the process. Trust the legal process. Go through the court system, let him face the trial, let him stand on the stand there, let him face the questions, and the trial court would decide that. Let's trust the process. That's what the DPP is saying. The Chief Justice counter to that is that prosecutorial discretion, as in deciding whether you should prosecute someone or not, whether it makes sense to carry someone through this whole legal process or not, is actually part of the process. That's why we have humans there making these decisions and not robots. And to me, that is actually another argument why you should not have something such as the bail bill, where you force a robotic answer that anyone accused of this specific crime does not access this bail. You want humans in the process. That's what we want. The prosecutorial discretion is a part of the process too. A part of the process that you want people to trust in the judicial process is the prosecutorial discretion, where we trust that the prosecution isn't going to push a case forward if it makes no sense. That's part of the process. We trust that. That's what we're supposed to be able to trust up there. But apparently, the DPP is saying that we should not have that trust in him. Yes. And to me, when I look at cases like that, those are the very cases that make me nearly always lean towards the side of protecting people from the system. As I've said before, the analogy I like to use is a lot of these systems, Ronnie, I see you join. A lot of these systems are so massive, are so grand, are so powerful. It's like a giant among the land, in the land of the little people. Gulliver's Travel. And as such, as much of the rules as possible when we're talking about this should be around how we curtail the movement and the power of this giant. We do not want this giant acting easily against the tiny people because the power imbalance is too much. You do not want the prosecutor's office to be acting like we're just going to prosecute someone and hope for the best. No, you have too much weight that can lean on your side. That's not something you want. But that's not the only case in the courts that we're looking at today. It's political season. And we already see how some of our two main parties are engaging in their politics and the road they're going down. And if this is already where it's at, it's kind of scaring me for when the elections actually go on and then the night of election results. Some of you who are familiar with social media on previous election nights, wow, it gets real disgusting. One of the things I like to do during some of those times is not necessarily look at some of the comments themselves, because those are the outrageous people. Look at the people who like some of those comments. Like, they won't make the comments out front and be bold with it maybe, but you watch some people and you're like, wait, That's what you're liking out there? Woo, I didn't know that. All right. And the thing is, these online comments in election season or not need to be careful, because you can be sued. And one of our political leaders of one of our political parties here in Trinidad and Tobago, one of our new parties, has found himself in expensively hot waters in the same court system because of some of those kind of accusations. PEP's Philip Alexander loses appeal in Udicut defamation lawsuit. The Progressive Empowerment Party's Philip Edward Alexander will have to fork out more money for his unsuccessful appeal of a judge's refusal to step aside from hearing a defamation claim against him. Alexander had appealed the March 3rd ruling of Justice Avison Quinlan Williams, that justice again, dismissing his recusal application and ordering him to pay $137,038.75 in costs to the Urban Development Company for the failed application. I find this should have demerits for inappropriateness for politicians. I understand what you are saying, Marie Emerald Camps, but as with most things, the problem with something like demerits for politicians is who is going to be in control of it. Who is going to be distributing the demerit points for the politicians? Who is going to say which politician gets how many points? And then if a politician gets so many points, what do? Do you forbid them from being able to run for elections? The demerit point system for politicians is the elections. That's what the demerit point system is supposed to be for politicians. Blessed night, Vanessa Scott. The demerit point is that if you see their actions are not lining up, then you vote them out and you demerit them. He only wants to know how the money was spent in refurbishing the Red House, as the cost was $0.5 billion. Well, he could want to know what he could want to know, but wanting to know something is different from accusing something. And the problem here, and this is something I always pay attention to. If you listen to most of my contemplations, even when I'm speaking here, and you see how I speak, I try to speak carefully. I try to use my words carefully. I will not come out and accuse someone of something that I am not aware of. And I find that some of our more boisterous political activists use some of their verbal liberties too loosely, and they're getting themselves in trouble. An accusation is something that must be able to be verified. I can ask, why does this cost this? I can ask, why is this person given this contract? I can ask, how much was this person paid for this contract? I cannot say that X person got X contract because there's boyfriend with X person and that is the only reason them get that contract and it's a bunch of corrupt people in that X company. Listen, I need to be able to verify those things. I need to be able to verify those things. He also sought to have Udicut's defamation claim against him struck out, but the judge dismissed this too. At a previous trial, the court ordered that a preliminary issue to determine whether Udicut was a public body capable of suing a citizen. Alright, I don't want to go through all the legal reading to get into that, because it could get a little deep. Let me see if I could explain this to you, because I read it already. So, he made some accusations against Udicut. And Udicut sued him for defamation. Now, Udicut is a corporation. So they have to figure out there's a preliminary issue where they're trying to determine whether Udicut, as a public body, is capable of suing a private citizen. That's something they have to determine, whether it is legally possible for a public body like Udicut to turn around and sue a citizen. That is something still before the courts. But while that is still before the courts, the payment in the ruling, the issue of the quantum costs were ordered to be paid $137,038. So 200,000 payments already put there. So the cost for the defamation suit was already put out there. Now, because the cost was already put out, he was saying that cost cannot be there because it isn't yet determined whether they can sue me or not. That was his argument. How can you give me a cost on what I'm supposed to be paying if you have not yet made the early determination? We haven't yet decided whether a public body could sue a citizen, so how are you telling me how much I have to pay them? That was his claim. And then his claim also was that because the judge made that order for the payment, the judge prejudiced the previous case where now they have to determine whether Udicott can sue him or not. Because the judge basically already said, you defame them. Because the judge already said that, now he is saying it prejudiced the earlier case on determining whether Udicott can sue him or not. At the appeal, it was argued that the judge, by making the cost order, predetermined the preliminary issue. She was also accused of apparent bias. Udicott's lead attorney Deborah Peake, SC, argued that the appeal was misconceived and frivolous. On Monday, the appeal court dismissed Alexander's appeal, saying it could not draw the conclusion of apparent bias, nor had Quinlan Williams predetermined the preliminary issue when she gave a figure for the cost order. So, although you said he may have had a little point there, Easy, the appeal court says no, he has no point apparently. In an oral decision, Justices Vashish Kokaram and Malcolm Holdip said ill-founded recusal applications should be discouraged as they scandalize the administration of justice. Kokaram said judges, in deciding if to step aside, must embark on a self-checking exercise to ensure that justice is done. The task of a judge is not to win a popularity contest, he said, as he spoke of the role of attorneys in advising their clients. In Alexander's case, Kokaram, who delivered the ruling, said the judge did not predetermine the preliminary issue of Udicott's status. He also pointed out there was no appeal against the judge's cost order and that Alexander's attorneys were given a full hearing on Udicott's presentation of their bill for costs. The underlying complaint is not that the judge was biased, but the court should not have made a cost order against him. So, what the appeal court is saying here, yes, Vanessa Scott, laughing at the names already get people in trouble, Vanessa Scott. Vanessa Scott laughing at names already getting people in bacchanal. You see, here you come again, laughing at people's names. Miss Scott, do not get my little life here in any trouble because you're laughing at somebody's name. All right. All right, so, but what the appeal court judge was saying here is they didn't appeal the cost that the judge gave them. So they didn't find a problem with the cost. And the judge didn't determine the preliminary matter. The preliminary matter is still there to be decided. If it's decided some other way, then some other ruling can happen. So, no, the judge didn't make that. And the appeal court seemed to have been particularly angry with him and his lawyers because they're saying the accusations that he brought against the judge are not accusations you should bring across so frivolously because they are very serious accusations, and they make the entire judicial system be brought under a certain kind of disrepute. And that may very well be why they hit him with that 100,000 lash. Kukaram said ill-founded challenges to the bench should not be entertained. He also said the issue of costs were an important feature in civil litigation, but had nothing to do with liability, since there are various stages of such processes which can incur cost orders. So the judge could have determined the cost, and you could have still done whatever you had to do afterwards in your preliminary hearing. Either way, leader of the PDP is out of some cash. Well, not yet, but he's being ordered to, pay some heavy money. In response to the court's ruling, Alexander said although the appeal court made the point that the appeals process was an avenue that kept the justice system working, it overlooked the fact that the threat of excessive costs undermined that safeguard. He pointed out that the substantive matter had not yet been determined. He said any decision going forward on his part will not be based on the pursuit of justice or the people's right to know, but on if I could afford the risk, especially when one factors in the arms race of senior and junior counsel fees employed by the state. So I think I fully agree with this point raised by Mr. Alexander. He's saying that although we're saying the appeals process is a process to allow us to, get justice. It allows us to pursue justice to the full extent. What he is saying, after seeing a certain cost given to him there, is that because of that 100,000 cost that may be waiting on you, it actually puts a serious chill factor on the regular person going through the appeals process. If you don't have $100,000 plus to risk, then if you think the state did something negative against you, you aren't going to go through that appeals process. Like, if you found yourself on the negative side of what the DPP did to the previous guys there, and you want to initiate the proceedings, and you don't have the finances to do such, and there's the threat that if you lose your appeal, then you might be paying back people. You have to sit here and wonder, well, this might not be worth it. And then if it is that the money that it costs someone to go through the appeals process, if the money it costs them to go through the appeals process is so astronomical, it makes it impossible for regular people to seriously consider doing it, then is that really justice? I could understand that argument. How much people does get sued by the state? It's not only if you get sued by the state. It's if you decide, if the state did you something and you want to carry it, you want to appeal it. It's multiple things. And if you do not have the money to carry it on, then you just have to sit and take the injustices. The actual judicial process, the process that we're supposed to trust, is supposed to have the appeals process in there. We're supposed to trust that process, that if something goes wrong in the earlier courts, in the lower courts, we can appeal it going up and maybe get justice. But if we cannot pay for it, then is it really justice? It might not be. It might not be. But nonetheless, let this nonetheless be a warning to some of us, to some of you, all of us out here in cyber world that use our Twitter fingers, or Facebook fingers, or Instagram fingers, or TikTok cameras, who use it very loosely. Be warned that so far, as the case stands, a state body sued somebody for defamation. Defamation cases, I think, are going to start to pick up. We are going to start to see more and more defamation cases in and around Trinidad. So careful what you say with your mouth. Make sure you can prove what you are putting out there. All right, folks, all right. There won't be any Mindful After live chat tonight on TikTok. I am feeling a little stuffy, so this is all for now. I hope you educated, informed, or entertained. And wait, before you go, make sure you hit that like button if you're viewing on YouTube, especially if you're viewing this on repeat. If you want to view this on repeat and you're looking at this on any of the other streaming platforms, you can head over to YouTube and subscribe to Nathan Springer, and you can catch the videos there. Good content coming from that YouTube channel, more to come. As I said, I hope you're educated, informed, or entertained, and that's all I have for now. I will see you again. Haha, red woman should start to sue people, could start to sue people. Well, you have to kind of be specific. There probably needs to be a red woman association first, and then the insult needs to go out to the association, and then probably the red woman association could sue somebody. But yes, I will see you again tomorrow 9:30 for the next